Just to be clear where we stand, you've made some statements during your argument that seem to me to suggest that you think that the mere fact that Congress did not say expressly that it was abrogating sovereign immunity is sufficient. That's the end of it. We don't need to look any further than that. Is that your argument?
No.
Okay. So then the question is what we can infer from what we see in the statute, right?
I don't think so.
In the relevant context.
No, I don't think it's what you can infer. I think there's two ways that you've said in Kurtz and FOMB that you can abrogate immunity and that you can abrogate the FSIA. Either some express language, which you don't have, or providing a cause of action against the government entities, in this case would be foreign government entities, which would be rendered a dead letter, which would be rendered meaningless.
Well, that's an interesting reading of Kurtz, but there's nothing in the opinion that talks to that.
Well, certainly there's something in FOMB, which Kurtz relies on, which says
Kurtz itself doesn't say anything about that.
It says negate. And I think that reading Kurtz in any other way would both be inconsistent with your precedent and would leave this court in all of those situations down a path of determining what's not a dead letter. Is it like in the expropriation exception? Is it that there are 1% of claims that can succeed? How are you going to determine that?
Well, if we knew that Congress thought that the immunity conferred by the Foreign Sovereign Immunities Act would wipe out 99.999% of the potential claims that could be asserted under Helms-Burton, wouldn't it be a fair inference that it did not intend to preserve the Foreign Sovereign Immunities immunity?
I think that the text governs because you can't determine whether it would knock out 99.99%.
Well, what's the difference between 100 and 99.9 or whatever? Well, in the case of 100, you're inferring. They wouldn't have created a cause of action against a foreign government instrumentality if it was a dead letter. It's an inference, and I don't understand why the inference stops the minute you can find 1 in a million claims that might get through.
Even if I agreed with you that you can make that inference. That's not the case here.
Well,
there are many claims